today's story, we are dealing with a follow-up for the Boston flag controversy. You guys may remember this because we covered it in a Supreme Court oral reaction in which Boston's argument sounded really, really dumb. Boston has flagpoles. One of the flagpoles, they fly the American flag. One of the flags, they fly the state flag. And the other flag, they fly other things on, including private flags. They have an application form that you fill out if you want your flag to be flown. And over the years, they had never denied anyone the right to fly their flag ever, until someone wanted to fly the Christian flag, which, as depicted here, the Christian flag, at least traditionally, is a white flag, but with a blue corner with a red cross on it. So that's what the Christian flag looks like. And they said, no, we're not going to do that. And Boston's arguments were really, really dumb, basically because they basically proved they had animus to religion. It was really bad. Well, after their victory, of course, they then went back to trial, and they've recently reached a settlement where Boston's going to have to pay for the denial of the flag because they were religious bigots. Let's get started with this. Boston resident Hale Shurtleff, the director of the Christian group Camp Constitution, has settled his lawsuit with Boston for $2.1 million. Well, Boston going to help some kids go to Christian camp. How nice. The Supreme Court ruled for him in May when it found that Boston's 2017 refusal to fly the flag had been unconstitutional. Boston allows private groups to have their flag temporarily flown in front of Boston City Hall. They sure did. Since the implementation, the flags that have flown have included ethnic flags, gay pride flags, Juneteenth, Battle of Bunker Hill flags, and many others, including my personal favorite, a flag of a bank. They flew one time, so that was special. They flew the bank's flag, but yeah, Camp Constitution was the only group whose request was denied. It sure was. Yeah, Boston argued its objection was grounded in commitment to avoiding government endorsement of religion as required by the Establishment Clause. Yeah, by having animus to religion. They just flat out have animus to religion. We're not doing the religious flags. No. Camp Constitution's official mission is to enhance understanding of the country's Judeo-Christian heritage, American heritage of courage and ingenuity, the genius of the United States Constitution, and free enterprise. Those are laudable goals. Maybe goals that Boston isn't necessarily 100% aligned with. Judeo-Christian, integrity, genius of the Constitution, free enterprise. That's that capitalism I keep hearing about. The group had sought to fly its flag below, which is contained below. And it's, the white flag with the upper left corner is blue with a red cross on. That's what the Christian flag looks like, more or less. The case proposed an important First Amendment question. Whose speech is it when the flag is flown? The private group or the city's? Well, yeah, if the flying of the flag was purely incidental of private expression, Boston would not have the right to impose content-based restrictions. So if it's just private speech and they've opened it up to everybody, then, you got to open it up to everybody. However, if by choosing the flag, Boston itself was making a statement, then it would be its message. But it's a little bit hard for it to be your message when you're flying flags of, for example, competing sports teams or competing nations or the bank. Not sure why that's a message you want to say. Ultimately, the Supreme Court ruled 9-0 that the group's free speech was at stake and Boston violated the Constitution. Yeah, they really went about that in a really, really bad way. They totally destroyed their argument. Outgoing Justice Stephen Breyer wrote for the court and reasoned the flag-raising program did not constitute government speech. Following the ruling, the case was remanded for further proceedings. As revealed by a settlement documents recently made public, the parties resolved their dispute on Tuesday. Under the terms of the settlement, Boston will pay $2.125 million to Camp Constitution. The case will now be listed as administratively closed, but the federal courts retain jurisdiction in the unlikely event that there's a problem with the settlement, but all they have to do is cash a check, so I think they'll be fine. The court's ruling in the Shurtleff case forecasted major changes to legal analysis of questions of religion. Well, I'm not sure that's necessarily really true. I think their reasoning was pretty in line with precedent, Smith being most notable. neutrality of religion. If you're going to make it open, you got to make it open. You can't treat religion any worse. They treat religion worse. I mean, it flies in the face, smack face first in the Smith, as I said. Ultimately, the justice unanimously ruled in Shurtleff's favor. The justice had different views on reasoning. In a spirited concurrence, Thomas and Gorsuch advocated for overruling long-used Lemon tests for Establishment Clause violations. Yeah, Lemon is dead law, but the Supreme Court refuses to acknowledge it. It's dead, but they refuse to say it. The lower courts use Lemon, but the Supreme Court doesn't use Lemon. They've never used Lemon. Lemon is this balancing test. It makes perfect logical sense, but it's just been hard to apply in reality. Like on paper, it looks fine, but in reality, not so much. It's really problematic. So yeah, we should just kill Lemon, but they refuse to do it. So yeah. The following June, the Supreme Court ruled 6-3 to formally overrule Lemon in Kennedy versus Vermont, a case involving a high school football coach who was not rehired after engaging in prayers on the sideline. Okay, yeah, I'm going to have to disagree with the article here. Although I would very much like the Supreme Court to overrule Lemon, I don't think they did. In Kennedy versus Vermont, they did not. Now, Justice Sotomayor in dissent said the majority did, but the majority never actually quite says the words. They say things like they long ago abandoned Lemon and moved on to other tests, but they never quite actually say the words that they overrule Lemon. So is Lemon still good law? Well, I'm not actually 100% sure because the Supreme Court treats it kind of like they did it long ago and no one noticed in the Kennedy case, but they never actually say the words. They never actually say the words. So they say that they formally overruled Lemon. I don't know about that one, man. They were very oblique about it. Sotomayor said the majority did, but the majority never said they did. And I don't know about that. Is Lemon still good law? And well, debates ensue, I suppose. We're pleased that after 5 years of litigation and unanimous victory, we are joined to finally let freedom fly in Boston, the cradle of liberty. The city of Boston, of course, did not respond for comment. Okay, let's wrap this up. Thus, that brings us to the end of the tale of Boston, who decided not to fly a flag. They did not fly the flag because they had religious animus in their hearts. They did not like the religious. And now they have lost, and now they've had to pay $2.1 million to Camp Constitution, which will use the money to further the mission of teaching people capitalism. I'm sure Boston is thrilled. But yeah, the flag, as you can see here, flew proudly over Boston City Hall. And so bringing a fitting resolution to this story, and that, at least for a moment, brings us to the end of the tale.